Good afternoon, everyone. Welcome on behalf of Trust Mediation to this, our last webinar in the autumn-winter season. Welcome to those who are joining us today, to those who are watching the recording of this session, and a particular welcome to guest panelists Ian Cohen of the Cohen Consultancy and Yaqub Rahman of Oriel Chambers. We're grateful to them for giving their time and expertise today. I'm going to mention a couple of things about logistics and then give an intro to the subject today. So, as mentioned, we're recording this session, and the recording will be available on Trust Mediation's website in a day or two's time. At the bottom of your screen, I think you'll find there's a Q&A button, and we invite questions, so you're very welcome to put questions to us. So if you'd like to use that Q&A facility. You have the option to put questions anonymously, and we will just read the question out. If you put your name down, then we will read your name as well as the question when we get to the Q&A session. Towards the end of the session today, about 1:45 or something like that, we'll poll you on three questions we've got about ADR and would like your views on. And to avoid the need for anyone to take notes today, when we talk about cases with names and references and sources and so forth, we're going to issue a PDF document which we'll be sending out to everyone after the session has ended. If you're viewing a recording of the session, then please, if you would like a copy of that PDF, just drop an email to registrar@trustmediation.org.uk and put ADR webinar PDF in the subject, and we'll send that out to you. So let me now introduce the subject that our panel is going to be talking about. We think that now is a very useful time to take a look at ADR and consider the recent procedural changes and discuss how ADR fits in with traditional settlements approaches such as JSMs. Why now? Well, because procedural changes are coming down the track, and the changed environment will give rise to opportunities to law firms and their clients, and also potentially threats. Today is not about the desirability of these changes that they're a given, and it's certainly not about JSMs good versus ADR bad or vice versa. It's much more about how to navigate these changes to best effect. For example, what steps would you advise a client to take if you were ordered to mediate at a directions hearing? We're going to get started by running through the recent developments that I referred to with ADR. And as I say, all case names and references and sources will be in the PDF. So I'm going to start by asking my fellow director, Philip Hesketh, fellow director and mediator, just to give us a nutshell summary on the well-reported case of Churchill. Phil.
Thanks, Tim. Yeah, I think probably well known to this audience, the Churchill and Merthyr Tydfil case. We did, of course, do a full webinar on it this time last year. It was December last year, just shortly after the case had come out. So you can see that on the website if you'd like to. In a nutshell, it overturned the understanding from the 2004 Halsey case that the courts weren't able to order parties to partake in some form of ADR, such as mediation. They made it clear in the judgment that the court could, and in certain circumstances should, make such an order. I can confirm, because I see the inquiries coming in to us, that this is happening. I wouldn't say it's a flood, but there are a small but growing and significant number of cases that come to us where parties, we always ask which parties instigated the mediation, and more often now we're getting the tick box for court ordered. So it is something which is happening, and we'll hear in a moment about how the CPR has changed, partly in response to this decision. Thanks, Tim.
Thank you, Bill. Yaqub, will you say a little, please, to summarise the amendments made recently to the CPR?
I think the reality is pre-Churchill and the changes to the CPR, there was pretty much a varied approach across the country in terms of dealing with ADR. Some courts routinely made orders encouraging parties to enter an ADR. Other courts didn't bother. Now it's clear, following the decision in Churchill, the Rules Committee has made significant amendments to the CPR. So the overriding objective at CPR 1 now includes a specific aspect where the judges are encouraged to promote or use alternative dispute resolution. In the Duty of Active Case Management 1.42e, it now includes ordering or encouraging the parties to use and facilitating the use of ADR. Now, interestingly, the rule submit is not defined ADR, and that may be satellite litigation in due course as to whether a party that refuses mediation or refuses some other form of ADR wants to negotiate will be held full foul of that. But under case management powers, it now includes the ability of the court to make a formal order that the party should participate in ADR. It's not limited in terms of the stage of the proceedings, and it's clear the court has wide discretion as to when it will order it, is actually encouraged to think about doing so. The CPR 28, which deals with fast track directions and also intermediate track cases, now also includes a consideration as to whether to order and encourage the parties to engage in ADR. So it's important not to think of mediation or indeed other forms of ADR simply in the context of high value cases. Traditionally, we've always thought of mediation when you've got lots of money at stake. Now, CPR 28 makes it clear that it will also apply in the context of fast track and intermediate track cases. CPR 29 obviously deals with case management, multi-track cases. And so the court now is specifically enjoined when giving directions to consider whether to order or encourage the parties to participate in ADR. The last amendment really is, as you'd imagine, is in the cost provision under CPR 44 and conduct. And the court will specifically take into account, when dealing with the issue of costs and conduct, whether a party has failed to comply with an order for alternative dispute resolution or unreasonably failed to engage in ADR. And in fact, there's a case from earlier this year, I think a commercial case, which we may come to talk about in due course, where the court did impose an additional sanction for a party's failure to engage in ADR. And that was actually a case where the High Court judge didn't make any sanction, but in the Court of Appeal they did. But we'll come on to that in due course, no doubt.
Yaqub, thank you. And Ian, can I turn to you, please, and ask if you can summarise the Civil Justice Council recommendations about changes to the pre-action protocols?
Yeah, sure. So as practitioners, one of the things that we've been trying to work out is what will this actually mean in practice, and the extent to which we're going to see the courts compelling, and the pre-action protocol compelling mediation in particular in the pre-action stage, or ADR as well, sorry. So the Civil Justice Council, I think it was phase 2 report, which just came out, contains some really quite interesting pointers, and it's worthwhile me actually reading the wording of it. And they said this: the working group believes that where parties engage in formal dispute resolution process with the assistance of a third party neutral at the pre-action stage, they should be exempt from automatic requirement to engage in mediation after proceedings are issued. So that is telling us quite clearly that the Civil Justice Council, and then when we see with the civil procedure rules and the changes to the pre-action protocol, that there will be a requirement for a third party neutral to have been involved in the pre-action stage. And if that is not the case, then there will be an option for the court to make it automatic and compulsory on any directions. Now, what will happen is the CPR will amend the pre-action protocol rules, and we anticipate that will come out either this coming or April in 25 or in the October. I think the reality is, looking at the momentum that is now behind this, we will see amendments to the pre-action protocol in April, and it will almost certainly be giving a very clear direction of this 2 points: either engage in pre-action ADR with a third party neutral, or be prepared to have it ordered as a compulsory element of the directions, which we are now seeing in any event starting to come through. So this will be quite significant changes and will give teeth to the pre-action protocols.
Can I just chip in on that point? Thanks, Ian. That in terms of pre-action intervention by using mediation, when we started working with the NHS scheme 4 or 5 years ago now, the vast majority of the mediations we did were post-action. That has changed gradually over the course of the scheme to the position we're at now, where more than 50% of the mediations are pre-action. So people thinking that it's too soon, surely, to be using a mediator pre-action. Our clients are of a different opinion.
Yeah, just on that point of it, just to reiterate, we know from the NHSR in their annual report, which came out, I think the one that made reference to this was almost 5 years ago, when the current chief executive, Helen Vernon, said about the desire of the NHSR to fish much higher up the stream. And what they meant by that was a much earlier intervention, and an earlier intervention pre-proceedings. And this is this continuing evolution of that which we are seeing. So absolutely, there is real opportunities to resolve cases pre-issue. And knowing what we know of the problems with the courts, then my view has always been that is a real incentive to everybody, the clients and both the claimants and defendant solicitors, to resolve them that way. And this trend is going to continue. So I would imagine, Phil, we're going to see more and more cases settling pre-issue, or being mediated pre-issue, should I say.
Thank you, Ian. And I'll just wrap up this quick run through the recent developments with just a brief summary of the digital justice system vision of Sir Geoffrey Voss, the Master of the Rolls, because the three summaries we've heard so far are all connected, and they're all underpinned by this vision Sir Geoffrey Voss has. His objectives threefold: to increase access to justice by allowing claims to be resolved quickly and at proportionate cost online. Secondly, to allow claims to be resolved more efficiently at lower cost and more quickly. And thirdly, to allow the dispute resolution process to achieve greater transparency and openness. Now, what that means in terms of the clinical negligence or personal injury sector is that what Sir Geoffrey Voss has in mind is connecting up and making interconnectable the claims portal, the OIC portal, mediation and arbitration portals, and dispute resolution portals that private enterprise can create or has already created. So he's saying the existing portals and new ones which will be coming on stream will be able to connect with each other and with the courts. The focus, he says, and the purpose of this, the focus is on pre-proceedings, online dispute resolution, and the application of the full range of ADR processes. And the way in which this is going to come about will be by standards and rules, which will be set by the Online Procedure Rules Committee. So we think there's been quite a lot of change in this area so far, and what the Master of the Rolls is saying is that there is more to come, which I think makes today's debate very relevant. Now, when we first started in ADR and mediation many years ago, ADR meant mediation and vice versa. But really, that's no longer the case. And Phil, can you just, when we talk about ADR, when we talk about mediation, can you just break that down a bit for us and tell us what ADR means today?
Sure. Well, like the Court of Appeal, I won't attempt a definition of ADR, but these are some of the things which you might consider. Let's distinguish between ADR involving a neutral third party. So starting off with ADR, which doesn't involve that, you've got
at this time of year, I think.
Oh,
sorry.
Okay. So you've got obviously just offer and acceptance, settling a case without the need to go to court. It's an alternative dispute resolution process. Part 36 offers. Going further, getting around the table at a JSM. That's an ADR process or a settlement day. That frequently take place. They're methods of ADR not involving a third party. Then ADR with a third party, obviously mediation. And the most common form of mediation currently used is what we call facilitative mediation, whereby the mediator acts as an independent neutral, assisting the parties to find effectively their own solution to the claim, a resolution that they can both sides live with. They frequently say won't necessarily be happy with, and probably better if neither side is happy. But that's a resolution that they can live with, that they've found themselves, they've come up with, and the mediator has assisted them in getting to that position. That's facilitative. Then evaluative mediation is similar, except that the parties ask or maybe even expect with prior agreement before the mediation started, that the mediator will give some opinion about some aspect of the dispute. It might be what do you, mediator, think about the liability prospects or the contrib or the claim for accommodation or whatever element it is, or what do you think the overall value of this claim is. It can be any number of things, but this will be agreed beforehand, so it'll be effectively in the mediation contract. And it may not be called upon. The parties might reach a resolution without ever asking the mediator to give an evaluation, but it may be that some aspects are asked during the process. The evaluation will not be binding, so the parties can ignore it or follow it and as they choose. So that's an evaluative mediation. Less common, far less common, I would say, than facilitative mediation, but perhaps will increase in use. So that is mediation. There was also, of course, arbitration. Arbitration in clin neg and personal injury cases, I think, has traditionally been thought of for very high value cases. However, we run another organisation, Trust Arbitration, and Trust Arbitration does arbitrations of low value claims from the OIC and increasing numbers there, where the turnaround for the decision from lodging the claim is over 95% of them are turned around within 7 days. So that's a growing use for the low value case, arbitration in low value claims. Then you've got sort of course, neutral evaluations. Used to be called early neutral evaluation, but the neutral evaluation can be at any time. So I think we tend to drop the word early. And a neutral evaluation, again, non-binding. Parties ask a person, it may be a mediator, it may be another lawyer, a counsellor, anybody they have confidence in, to give an evaluation of the case. And again, as I said earlier, on the mediation, it can be on virtually any aspect of the case as the parties have agreed in advance. Again, non-binding, but an evaluation provided to them for them to do with what they choose. Then there are sort of hybrids of all those things. So you might have med-arb, but mediation, arbitration. You start off with a mediation, you see how far you get, you might resolve the case, in which case it's done. If you don't resolve the case, then it may be that the parties have agreed, not maybe, the parties have agreed in advance that will then turn into an arbitration, and then there'll be a binding decision given. Mediation with neutral evaluation can also follow, perhaps similar to the evaluative mediation, but you've got a mediation, and if it doesn't resolve, the parties can't reach resolution, they then turn to the mediator and ask for the mediator's evaluation of the case, and then they go off and do with what they want. It may be that they come back and re-mediate after that, giving that some consideration. So there are a number, I think, of processes which you can describe as ADR. Which is best for clinical negligence? Which is best for personal injury? I'm not going to say the obvious mediation. It depends entirely on the parties, and we will look at some of the factors a little bit later on. But you can see from that long list that ADR is very flexible, and really whatever suits the parties best is the best choice. I hope that's not vague and unhelpful, but we'll certainly give some pointers as to when, for example, a mediation may serve the parties better than a JSM. Thanks, Tim.
Well, thank you very much. And I think we've set the scene there by looking at what's been happening in ADR and what is meant by the terminology these days. I want to, having set the scene, to get the meat of our discussion now, and look at JSMs and mediation side by side. And I'm going to put questions to Yaqub first and then to Ian, because you're both practitioners, counsel and solicitor, who've got experience of using JSMs and mediation for claims of this type. So what I'm asking you is, how do the different approaches appear to you? And what has been your thought process when you've been deciding to advise a client or perhaps a colleague to use one approach rather than another? Yaqub.
It's a tricky point, this, because lawyers are known for having big egos. And most lawyers like to take the view that, you know, a JSM is the way to deal with it, because between lawyers, you'll just thrash things out, discuss your case. Negotiation is one of the modules that I was taught at bar school. Solicitors are taught the same thing, and negotiations, the bread and butter, as it were, of litigation. And certainly I come from chambers where mediation was not necessarily, amongst older colleagues, seen in a positive light. One described it as trial by attrition. Another said that his job in a mediation was to avoid the mediator talking to the client. There's this distrust of, as it were, the so-called neutral third party. I've had significant experience of both JSMs and mediations. In fact, several mediations over the last few weeks in clinical negligence cases. My own view is, if you have, for what it's worth, a simple case of horse trading where it's just about working out the money, there's no emotion involved, the solicitors get on or the counsel get on, you've got two teams of litigators who are quite happy to negotiate terms of settlement, but without a client who necessarily is emotionally invested in the litigation, well, a JSM makes sense because the lawyers can thrash it out. However, that's not the reality of most PI and clinical negligence litigation, in my experience. And certainly where there is an emotional involvement, either by the client, because there's a bereavement, there's some kind of awful injury, life-changing injury, or otherwise, where there's more at stake than just money. This is about somebody's life who's changed. And I speak as somebody who does mainly defendant work. For the defendant, it's about resolving a situation. But for the claimant, you can't lose sight of the fact that if they're in litigation, it's a once-in-a-lifetime experience and one they don't want to repeat. And therefore, there's an investment there that, to my mind, is not necessarily addressed by lawyers in a room, going backwards and forwards, discussing, as it were, pound, shilling, and pence, to use old money, as it were, because I'm that old. So for me, the decision is between a relatively straightforward case where the lawyers are on board and can negotiate figures, in which case a JSA makes much more sense. It's quicker, the lawyers get to the point, there's no one who's worried about any kind of discussion. And to my mind, the vast majority of cases where you do have emotional investment by either the client or the lawyer, because lawyers don't always get on, surprisingly enough, on both sides. And sometimes they can get so entrenched in their position that actually negotiations don't work and you need a neutral third party. So I have to say, over the years, I've become a convert to mediation as a tool to break impasse and create a better environment in which to settle a case, but also create a better environment for claimants, particularly, to feel that they've been listened to. And that often is something that's forgotten about in the context of negotiating a settlement.
Yeah, thanks very much. Can I turn to you, Ian, for solicitor's experience and your thought process when comparing which way to go on these two options?
Sure. So my background is as a claimant clinical negligence lawyer, so I'll be talking very much from that perspective. But what I have to say, I think will also apply to the personal injury side of things, save for one aspect, which will be the patient safety. I historically was always of the view that a JSM was the appropriate way to go through, because by the time you get to a JSM, you are very much in the process of making a decision or trying to negotiate a position in relation to the percentage of the case by way of a reduction for the risks of the litigation, and then the actual quantum aspect of it. And historically, for many, many years, especially in my early career, you would have a scenario whereby you'd have a traditional 3-room setup. You'd have the claimants in one room, you'd have the defendants in another room, and then you'd have a room where every so often the claimants and the defendants would come together. The amount of time that a actual claimant was involved in a JSM was very, very limited, and it was not uncommon to only have the claimant engaging with the defendant team once a resolution had been occurred. You'd have a settlement, and then the defendant team would come in, and then they would say stuff about, really sorry, but please, we've now achieved a resolution, and that you can try and move forward with your life. And I think the point that Yaqub says about it's quite a sterile environment. It is a pound, shillings, and pence. And there are certain cases and there are certain clients that it lends itself. And I think one of the important things in deciding whether or not to go down the route of a JSM, whether or not to go down the route of a mediation, is really understanding your client and understanding what your client wants. And this then really brings me to my personal experience and where I changed my view when it came to mediation. And we had, in fact, on a particular piece of litigation, it was part of an ADR protocol that we tried to resolve it, but we couldn't. And as a last ditched attempt, we decided to have mediation. And what struck me about this mediation was a point that Yaqub touched on towards the end, was about this concept of a patient's voice. And I think this is important both in a PI case, but also in relation, and I think in particular into a clinical negligence case, where we all went into a room, we all knew each other's position, and the first person to speak at this mediation, when we were sitting around the table, was in fact the patient, the claimant. And what she had to say completely set the tone for the rest of the meeting. She felt listened to. She felt that she was able to get a point across other than simply the financial aspects of the case. And this was a case where liability had been admitted and it was purely one of quantum. And she was so powerful in what she said, it has stayed with me ever since and completely changed my view as to the power of mediation. And that idea about giving a client a voice in the process must not be underestimated, because one of the things it did was her demands, if I can put it that way. She felt that the only way she could get a point across was by maximizing the financial compensation. Once she'd actually been able to speak, once the defendants had actually listened to what she had to say and she saw their reaction, she was more than happy to then look at a financial compromise that wasn't just about making a point. And as a result of what she said, the defendants also realized that actually they didn't want her on the witness box. And they realized that they really do need to try and resolve this. And so there was a movement in the parties as a direct consequence of her speaking. And that, to me, was one of the most important lessons I've learned and the real advantages of mediation. In the clinical negligence context, we've also got the patient safety aspect and the lessons learned. If we simply have a JSM, it is quite difficult to deal with, well, okay, so there has been an act of negligence. There is admission as to breach of duty and, to a degree, causation. And we're just arguing about the actual value. It gets lost a little bit about, well, what lessons have been learned to avoid this happening again? And within a mediation context, and several that I have done, sometimes what you get is, if the trust is properly invested in the process, they will bring a patient safety individual to join the process. Sometimes you can get somebody from the NHSR to join the process. And you can really hear when you have that environment about what lessons have been learned, and again, how this can impact upon the wider position of patient safety. And so mediation, bringing those 2 points together, gives the opportunity for all parties, and I think in particular the claimant, to get far more out of the process, where they feel that they are listened to, they feel that lessons are learned, and they feel that steps can be taken to avoid this happening again in the future. And that, to me, is the real difference between a JSM, which is on the facts and figures, as opposed to the mediation, which brings much more of the human aspect into it. And I changed my view. And there are certain cases which really do lend themselves to mediation, and there are certain cases that lend themselves to a more traditional JSM. Know your clients and make informed choices once you've told them what is open and what the advantages and disadvantages are. You're on mute, Tim.
There always has to be one, doesn't there? Thank you. Ian, thank you very much, and yeah, thank you for that. Just a couple of observations from me, and I'll bring Phil in. But in terms of that, the claimant's voice in the mediation, I think is particularly important. It's not something which is necessarily excluded from for a JSM, but even on a relatively straightforward case, what we regularly see is there is quite a big difference between the bottom bracket of the claimant's figure and the top bracket of the defendant's valuation. And on the base of it, there are two legal valuations. There is a big clash in terms of valuations of the case, valuation of the risk if liability is also at stake. And the position looks pretty hopeless because those valuations are a long way apart. But the interesting thing for me is even in a straightforward case, which is only about money, settlement comes from exploring the gap between claimant's bottom bracket and defendant's top bracket figure. And there's all kinds of things which have an impact there on the decisions on both sides to settle, as appetite to proceed to trial, appetite to risk, which is closely associated with that, funding issues. From a claimant's perspective, the wear and tear on the claimant and the family, and the desire to have things over. Occasionally on the defence side, there's a reputational issue. And all of those things come into play. And that's where, as a mediator, being the only person who goes into both rooms, whether virtual rooms like today or physical rooms, you're actually getting the temperature of both rooms and where people really are and what the desire to settle is, because people can express a desire to settle to a mediator that they're not going to dream of hinting at, even with the other side. So that's, I think, one point of interest. And it's always fascinating to me that when people say, well, no, we can't mediate this case because we're too far apart, most mediators will say, well, actually, the mediation, one of the great purposes of a mediation is to explore why you're so far apart and then to analyze that and to see what can be done about it. And it's amazing how many times you do see a gap. Sometimes a gap of millions of pounds comes down to a Tomlin order by the end of the day. The other thing, Phil mentioned some particular pointers towards mediation, and it's not uncommon in personal injury cases as well as clinic to see more than one defendant, and that gives rise to a whole different settlement dynamic. And it's often the case we find in both types of mediation that the relations between the defendants can be rather more tense than between the defendants and the claimant, and there the mediator is involved in several mediations. But it's ideally suited because those disputes are ideally suited to mediation because the mediator can move between the parties, find out what the claimant's settlement figure is, and then get that money from the defendants, because again, there is this catalyst, this person who can go around all of the rooms to do that. So those are some of my thoughts on what Yaqub said quite rightly, I think, at the outset. It's not an easy decision on when to mediate and when to use a JSM. It's a lot easier, I think, if like Yaqub and Ian, you've got experience of both rather than experience of one. Phil, any thoughts from you on the pointers between when to go one way, when the other?
Sure. Just going back to Ian's point about the involvement of the claimants in mediations. I think some claimants might be afraid of that, thinking that, I think it's important to assess it's an empowerment. You know, they can I think all the trust mediation mediators approach this with the view that putting the claimants at the centre of the process and inviting them and empowering them to take as much part in the process as they wish. I've often had mediations where I've heard the claimant say to their lawyers, I'll go with whatever you say, just, you know, I'm in your hands, and they want to sit back and they don't want to be involved in any joint meetings. That's entirely up to them. So again, it's that flexibility of process. So it's an empowerment rather than an enforcement of participation in the process. And on the multi-defendant cases, that's absolutely key, that often there's two mediations going on as described, and sometimes one idea is just to get the claimant out of the picture, so that the defendants, if they can't manage to resolve matters on the day, can take things away. But at least the claimant is out of the picture, and the costs there are not rising any further. There may have been, Yaqub was saying, with cases where the party, the solicitors or counsel can resolve matters through a JSM, fine, but you can't always predict in advance whether each party is going to stop, when it's going to reach its end position, and there may be a significant gap still, and usually with a JSM the parties will go home, and they may even go home before they've found out truly what that real gap is. They may kind of give up, seeing the position that the early moves are not as significant as they'd hoped. It may disencourage them, and they may leave the process without really understanding what the true gap between them is. And I think that's where the mediator with their impasse breaking can assist. And it's a case where they can assist where if a JSM has happened and and not resolve the matters. It may be that you can then turn to mediation. I've certainly mediated cases where JSMs have failed. I've even mediated cases which I've mediated before, so they've come back for a second go. So I think they're some of the points I would add.
Thank you, Bill. I want to move on next to look at probably a more subtle approach to this question of mediation or JSM. It's not always simply a question of that. And I do anticipate, and I've heard some particularly personal injury practitioners say, well, all this development on ADR doesn't really affect me because we use JSMs towards the latter stages of the case, and that's what we'll continue to do. And I think that strategy may come into some difficulties. And firstly, bearing in mind what Ian had to say about the potential changes to pre-action protocols, it looks as though there's going to be, probably by next year, a requirement to use some kind of formal ADR pre-proceedings. So leaving a JSM until the exchange of witness evidence wouldn't be a sufficient strategy there. The other thing to bear in mind is a couple of things to bear in mind is if a JSM does not result in a settlement, as you've said, Phil, most of us at Trust Mediation have come across cases which have come to us following a JSM which has not produced a result. So that strategy may mean that you're going to a JSM and then to some other form of ADR. But I think of particular interest, which may also give rise to a concern for this strategy, is the use of ADR for discrete issues. We've been talking so far in using ADR or JSM to settle the case, all of the issues in the case. But there's been an increasing number of occasions where the courts have used ADR for discrete issues. Hadley and Prisbalow is one such, where there was a clinical negligence claim with the budget, I think something like £1 million on the budget, and many, I think almost 100 of issues in dispute regarding that budget. And Master MacLeod, as she then was before retiring from the bench, said to the parties, "We'll go off and mediate. There's no need. It's not desirable for the court to be locked up in dealing with these 100 issues in dispute. With cost lawyers, you'll mediate those and knock most, if not all of them out." And indeed, the parties did go away and mediate and found the process very helpful, and they agreed the budget all bar one issue of principle, which came back to the court. The same judge in Elphick and the Times concluded the case and said, now the costs in this matter, the detailed assessment, is going to be a very considerable dispute from what I've heard so far. So I'm ordering you to go away now and to mediate that. And that was the order with the added bite of a cost sanction if that didn't take place by the time the detailed assessment came before the court again. There have been a couple of other cases where there's been issues regarding budgets, And when the budgets finally were dealt with by the court, there were considerable amounts wiped off of the budget, and it wasn't costs in the case, as is usually the situation here. The judge said, no, you should have negotiated about these matters. You were given time to negotiate. You didn't do so, and so there's going to be an adverse costs order. And I can see, bearing in mind the length of time that detailed assessments, that the length of time people wait for directions on CMCs and so forth, that there could well be an increase in the use of mediation and other forms of ADR there. So that's, I think, something to bear in mind if your ADR strategy is the one-liner of we'll do it later on after expert evidence. Phil, Yaqub, any observations on that yourselves?
I think, can I just make this observation? I think part of the problem is litigators, when you train as a lawyer, you're almost trained to think in competitive terms. All you're thinking about is that process of, we've got a dispute, we're going to trial, either we're going to settle the case because we've got no defence or whatever the case happens to be. And I think there needs to be a change in your approach as a litigator to think ADR from the outset, that actually what's in the best interest of your client, whether it's an insurer, NHS or whoever, what is in the best interest of your client? It's not about you as an individual and how good you are as a litigator, it's about your client, whoever that happens to be, and what's in their best interest. Will it save costs? Look at ways of trying to resolve issues rather than look at ways of trying to, as it were, approach litigation, which is essentially a zero-sum game, as I know gaming theory describes it as. One wins, one loses. Mediation or ADR means that you both go away with something out of it. And I think part of the problem, as you highlight, Tim, is that we're so conditioned to think of trial that we don't think about ADR enough. And in some respects, and I hasten to add, I'm not on any commission from Trust Mediation or the other third-party ADR organisation. You ask yourself, what is the actual disadvantage to mediation? What actually you lose? You then give it your best shot, even if one party you feel isn't coming to the table with enough there. The mediation gives you the best possible shot, or some form of ADR, the best possible shot at trying to settle a case. And that's got to be in the best interest of both parties, because it buys off that risk. And so I'm like Ian, I'm a convert to mediation as a form. There are some cases where I much prefer a JSM, but in reality, that's the impatient part of me. JSMs can be a bit quicker, but they can also be a bit more combative. You expose both parties' egos. You rely on your relationship with the other side when you're trying to negotiate. The mediator takes out the sting. And for me, the most important thing that I've certainly discovered from cases involving either serious injury on PI side or clinical negligence cases involving life-changing incidents, whether it's death or otherwise, is the claimant, the individual who suffered the wrong, is the person who gets hurt. And they don't get hurt in a JSM in the same way. And for me, that's one of the powerful factors involved in why you choose mediation or a similar form of ADR rather than going to JSM, and you apply that to any significant dispute. I'm not sure I'd be wanting to resolve costs on every multi-track case dealt with by mediation, but most of the time I find cost lawyers are quite good at dealing with those matters. But if you have something like Master McLeod's case, then mediation works perfectly.
Yeah, thanks for that.
Can I, yeah, Tim, yeah, a kind of slight counter from my background. Started as a claimant lawyer, and I did that for about 20 years. I never did a single mediation in all that time, because back in the day, why would I? I'd got a case. I thought I could win it. I'll make as much money out of this as I can. Yeah. So why not carry on doing that?
Ian, what do you think about the commercials of that approach of letting the case run?
Okay, so if I can, there's been a couple of things I just wanted to flag up, and I will deal with the commercials. Two quick things about why to choose mediation. One of the things to bear in mind is that a client can be and will be intimidated by the whole process. And a lot of clients will then be very reliant upon their claimant solicitor and will effectively, in the nicest possible way, hide behind the claimant solicitor to do all the running when we're dealing with the defendants. One thing that I have noticed, the real skill of a mediator is to put the claimant at ease. And I've had a couple of situations where my client will say, no, I couldn't possibly say anything in the lead up to the mediation. And then having had that first introductory meeting, realizing it's not as scary, has then said, actually, I do want to say something. So that goes to the empowerment point. That's the first thing I wanted to stress. The second thing I wanted to say is that it is a mistake to assume that mediation, JSMs, or other types of ADR only work in higher value cases. There are some cases, and in particular in the clinical negligence, which could be where we've got the death of a parent, the death of a very young child, where the actual value of the claims are really quite limited, but the emotional value to the family, to the claimant, is far greater than 13, 14, 25,000 pounds. And there are those cases that really lend themselves to bringing the parties together to have the conversation, because it's more than just the money. And that works in the lower value claims.
Ian, can I just chip in on that point? Exactly that, the value of the claim. Our stats show us that the settlement rate, usually around 75 to 80%, is the same across all value bands, whether it's the multi-million pounds or whether it's those lower value, equally, often arguably worth an awful lot more, but nonetheless lower value for whatever reason. The settlement rate is incredibly similar right across the picture.
Okay, thank you. Well, I then wanted to pick up on the commercial sides, and something that Yaqub also said. It's about having the mindset about putting the client first and understanding what's in the client's best interest. Of course, that's what we should be doing as a starting point, but equally, we also need to have a mindset, again, I would say, particularly as claimant lawyers, as are the financial advantages to the law firm to going down the route of ADR, of JSMs, of mediations. And I'm a firm believer that there are. And if we go back to your point, Phil, which you said in a somewhat challenging way, that stay in a case for as long as possible and earn as much as you can. What is clear is that if you manage to settle a case where you have, let's just say, £30,000 worth of costs, compared to a case where you've got £150,000, when you look at the percentage of WIP recovery, you generally recover a much higher percentage of your WIP when you are talking slightly lower figures for costs. So you would recover, let's just say, by way of example, 95% of £30,000 worth of WIP, whereas you may get 82% of £100,000 worth of WIP. Now, there's all sorts of consequences to take into account. First of all, what ADR in all its forms do enable a case to be resolved sooner than later, so it has the benefits of cash flow for the claimant firm. That's the first thing. Secondly, and which is something which is becoming more and more of an issue for claimant law firms to understand, and not just within the realms of lower value claims, and that is about shortfall costs and the solicitor client element of it. And the point being is that the longer you run a case, the bigger your level of costs are, the greater the chance is that there'll be a shortfall. If there's going to be a shortfall and you're one of those firms that charge your clients a shortfall, then knowing the way the case law is going, that shortfall is also now being challenged if you don't do it correctly. So there are advantages, real advantages, commercially for a law firm to embrace ADRs, JSM mediations. Now, it may mean that if I was to stay in a case to trial compared to go into a case that settles quite a bit earlier, I may earn less money, but actually I have the benefits of cash flow. I have the benefits of ensuring a higher WIP recovery rate. I have the benefits of reducing any solicitor client shortfall. And the reality is that if you run a caseload whereby you are resolving cases quicker and you have the cases to replace the ones that you're solving, you will be more profitable as a business than holding out for the much bigger cases and staying them as long as possible. So not only is it in the client's best interest, but I'm a firm believer that for the law firm itself, by embracing it, is actually financially beneficial and actually will make the work more profitable.
Yeah, thanks very much. That's a particularly interesting perspective on the commercial view, because the reverse is often put and talked about in this context. Just another word on the versatility, the flexibility of mediation, and is it and ADR generally, are they just for higher value cases? And that flexibility is shown by the arbitration that Phil has mentioned in the OIC claims, which our sister company Trust Arbitration is doing. But also we got the DOH scheme, which in clinical negligence for cases under £25,000, which keeps kind of hovering into sight and then emerging into the long receding into the long grass again. That's got neutral evaluation, I think, as the ADR there. And if that proceeds, I would really like Trust Mediation to be putting forward an arbitration scheme for that, because I think with the lower value cases, and some of those may need to be mediated because they are, to use Yaqub's language, there's big emotional investment in them, and where there's been a fatality, then mediation may be the right thing. But where it's a straightforward money claim, it seems to me that arbitration would be a good solution for both parties, in the sense that it's speedy and gets a definite result, which is important in the lower value cases where costs, the margin on costs is so much thinner. So that's one example of the flexibility. The other is that on the intermediate track in personal injury, one of the things that we should be working on at Trust Mediation in 2025 is an online fixed hours mediation, so that mediation is available online for a fee which is proportionate to the value of those intermediate track claims on fixed fees. And bearing in mind since the pandemic how a lot of mediation has gone online and stayed online, that's a very successful way of dealing with cases at a proportionate cost. So those are some of the examples of flexibility of ADR. Let me pause there to mention the poll which has been on my screen for a while. If you've not been able to complete that yet, perhaps you'd like to do so.
And thank you to a lot of people have responded. Thank you very much indeed for that.
Are there any readout results, Phil, that are available to us?
Well, the vast majority, 90% of the respondents say they are going to be doing ADR. ADR training is on their agenda for next year. And 85% believe there will be an increased use of ADR with third-party neutrals next year. The other answers, which the question of why the personal injury legal community hasn't taken up mediation in the same way that it has been in clin neg, in probate, in commercial, and many other fields. That's a long answer, which doesn't. I can't give percentages. So we'll look at that and we'll analyse that and we'll share that in due course. But thank you for taking the time to respond to that.
I did say that we would deal with one point which I think is particularly important, and that is a tip to avoid cost sanctions. If you are in the situation where, having discussed the matter with your client, you're going to say no thank you to some form of offer of ADR. And the tip is simply this, and consistent with case law on the point, that it's absolutely essential to give contemporaneous written reasons for that decision. And in doing so, it is really necessary to understand and be abreast of the case law on the subject, because this case law goes back pre-Churchill and continues to apply. And many of the reasons given, I find particularly in the personal injury sector, would not, according to the case law, really bear scrutiny. I've already referred to reasons such as the gap between us is too big. Well, many judges have already said in case reports that is a reason to use ADR, not a reason not to. There's also case law going both ways on the question of, well, we've got an absolutely tremendous case, so there's no way we're going to discuss settlement of it. That, I think, increasingly will get short shrift from the courts. There's also the question of, well, we might do ADR, but we'll do it later. You know, we can put it off for now. So we're not saying no, because that would be dangerous. We'll just say we'll do it later. And I think, again, that will get increasingly short shrift. There's already a Court of Appeal case, PGF, where a party sought to refuse ADR on the grounds that they needed expert evidence. And the court said, well, no, you look at the case and you see whether expert evidence is actually necessary to enable you to discuss matters. You do not need a trial bundle to discuss settlement of a case. And in that case, they found that was that was unsatisfactory. Another case we heard recently, a post-Churchill case, in fact, earlier this year, was a party at directions, and the judge asked, well, are you going to look at mediation for this case? Yes was the answer. We're going to do that in April. And the court's view was, no, that's not satisfactory. You can get on with it much more quickly than that. I'm going to order you to mediate by the end of February. So bear in mind these judicial attitudes and changes that we've referred to, and the Master of the Rolls vision we've talked to, they are already changing judicial attitudes. So if you're going to be in a situation where you need to follow instructions to refuse ADR, it is really important to be abreast of that case law and to give written reasons which are going to stand up against a cost sanction. Now, I think we've covered most of the items on our bullet points. I'm looking at the questions to see whether we have any questions, but so far, despite this being a potentially controversial subject, we've not drawn any questions, which means that people are keeping their powder dry. So this question will continue to run and run, I'm sure, because there is a clash between the way ADR is going and the personal injury sector, which has not been tremendously involved in ADR to date. So that's a point of interest for 2025. I'm just going to ask our panelists if they've got any, as we've got 2 minutes left, any concluding points before we finish. Ian, anything from you?
The landscape is changing. There is no doubt about that. The landscape has changed. The rules have changed and will continue to change. The judicial view on ADR and resolving cases by way of all forms of ADR is definitely becoming much more of a focus for them. Add to that, it is in the client's best interest. I think we all agree that ADR in whatever form must be considered and considered properly. And as I said, I actually think the commercials back it up as well. So for me, there is absolutely no reason why not only should we not be making sure we are compliant with the change, but we should actually be embracing it fully because it is in everyone's best interest. So for me is get yourself up to speed, know what you're doing, be on the front foot and drive the discussion. Certainly from the claimant side, I think is really important.
Yaqub, I'm going to ask Phil to answer Cam Wareham's question in the question, but any final remarks from yourself?
Only in the sense there has to be a change. I'm a more experienced lawyer than many, having been around for a long time, but the landscape has completely changed, as Ian points out, and with the new rules and higher courts much more willing to impose sanctions, ready to mediate. I think both on the PI side and the clinical negligence side, there's going to be much greater drive towards looking at mediation with a view to saving costs for all concerned and to give, as it were, resolution at an earlier stage without the lottery of litigation. And we all know that litigation is, in some respects, a bit of a lottery, and we need to change our mindsets as lawyers as to how we approach disputes.
Thank you for that. Phil, expert determination.
Well, I'll dodge that one. And let me just say that, do ask what's in it for you, in mediating, because I think that's an important question. So look into that. If you think there's nothing in it for you, reconsider and have a look at that. So the question is, any views on the use of expert determination? I'll leave that open to anybody who wants to chip in.
I think that's a really tricky area, because I think part of the evaluative mediation, where you've got gentle third party, is one thing where you're trying to give a view on a particular aspect of it. I think expert determination falls in the same category as a single joint expert, particularly in PI. A lot of parties are just not going to accept an answer which is adverse to them, and it's effectively almost like it's non-binding with expert determination, or would be subject to the agreement of the parties. And so I think it's a much more tricky area. I think parties generally are stepping their toes into, as it were, alternative dispute resolution. I don't think parties are yet ready to as it were, place themselves victim to a chosen expert.
I think in Clin Neg it's even more acute. Right now, that's a bridge too far. It's not going to get any traction at all, is the reality.
Well, that's some
Sorry.
thumbs down on expert determination. Another space to watch.
The
I'm going to draw.
Can I just one more point? So I know we're adding late. It's just to say, don't be that party that does their first mediation because the court's just ordered it. Okay, we're here to help, and we can answer questions and we can provide training. So be prepared, be ready for it, and we'll do what we can to help.
It's also a prompt for me to mention that Trust Mediation has been approached for ADR consultancy on setting an ADR strategy for a firm, and we'd like to see some more of that, and are very interested in talking to firms for that. But well, we're out of time now. Thank you to our panelists, Yaqub and Ian. Thank you to Phil for this, and thank you everyone for joining us.
Thank you.
Goodbye.
Bye.